We have a lot going on here. We've been delayed a little bit. We've been on Liana this time, but we're back on track. And we've got several cases to address in the matter of Brody Jack Johnson. Mr. Johnson is somebody I've known for a while. He's here. He's got two lawyers. In file 252083, he's charged with larceny less than $200. That's alleged to have occurred on September 9th of 2025. He's represented in that case by Mr. Ross Truckee. In file 252126 SM, he's charged with assault and battery. He's represented in that case by Mr. Paul Gibson. That allegedly occurred on October 7th of 2025. Abigail Stoll and Gary Gaby are here from the prosecutor's office. Defendant also has a status conference and a bench warrant issue in a circuit court case, which is file number 202525895 FH. And Mr. Gabri's here on that matter, and Mr. Truckee represents the defendant in that case. At one time, there was a plea offer that Mr. Johnson could plead either to the assault and battery charge or the larceny charge. The other charge would be dismissed. In light of the fact that Mr. Johnson failed to appear on multiple court hearings, and he has a new charge where he's represented by attorney Rhonda Ives, and potentially another new charge if the prosecutor charges absconding, that there are a lot of moving parts here. But let's start with just the pretrials on the two misdemeanors. Mr. Truckee, you're at the podium. Do you have something you'd like to help us to move forward?
First, I'd offer my apologies to the court, the prosecutor, my client, Mr. Gibson, and Mr. Bingaman for my delay in getting this in today. Mr. Johnson would plead, though, to larceny under 200 in my file and assault and battery in Mr. Gibson's file to resolve the misdemeanor matters.
All right, Mr. Johnson, let's talk about that. Let me get these up. I'm in the circuit court database, which is foreign to me. I'm not trying to be unkind, Mr. Johnson, but I think 10 days in jail has done you some good. You look better today, more clear-eyed, clear-headed. But let's talk about these. The first charge is larceny. Alleged you took some semi-tire rims that belong to JTC Enterprises in Lockport Township. That's charged as what's called a simple larceny. It's under $200, punishable by up to 93 days in jail and a fine of up to $500. The other charge, assault and battery, alleges that on October 27th, you assaulted Mitchell Salmon by punching him in the face, I think. That's also a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. You have a right to have a trial on those matters. You also have a right to plead guilty. If you do plead guilty, I will represent to you that I will run whatever sentences I impose concurrently. That means at the same time, rather than a jail sentence on one and a jail sentence on the other. Whatever sentence I impose, I would run concurrently. So other than what I just said, has anybody promised or anything to get you to plead guilty to this?
No.
Or threatened you?
No.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. We've actually got 3 attorneys, but 2 of them are here today. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. You'd have also the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. And if you didn't wish to have appointed counsel, you could hire counsel, but we'll certainly make sure you have an attorney to represent you in these matters. Do you understand?
Yes.
All right, let's talk about the assault first. I think you and Mr. Salmon have had some bad blood for a while. Were you over at State and Maine and you had contact with Mr. Salmon?
Yes.
He was on his bike. Did you strike him?
No, he was just trying to talk to me. And at the time, he had lived with me just before that, but he had there was a matter where several $1,000s was taken from my girlfriend, so I had kicked him out. And then he tried to come back to me and tried to say, hey, I didn't take the money. But what can I do? I was like, well, it doesn't matter. You still let the people who did take the money into my house. And I told you beforehand, don't let anybody in my house whatsoever. And
so did you knock him off his bike?
When he come up on me and put his tire in the air and he rode up on me, it felt like he was gonna hit me. And then I picked up the wood, fell backwards, and I just picked up the wood and swung.
All right, that's sufficient. That ain't exactly the crime of the century. You had some jail time. You got arrested on the 20th, I think. And you got arrested on the 21st. And then you failed to appear for your pretrial. We did a bench warrant. And then you got arrested on the 24th. And then you posted on the 25th. So that's another day. Then you failed to appear again. And you got arrested on the 24th. So you have 2 days plus 10, which is 12 days credit on that case. All right, let's talk about the larceny case. Mr. Truckee, why don't you have a seat for a minute and we'll have Mr. Gibson on the larceny portion of this. No, wait, I got it backwards, Ross?
I'm the larceny.
Oh, you're the larceny case. All right, well, stay right where you are. You're doing fine. All right. Again, Mr. Johnson seems very clear-headed today. Sure of himself what he's doing here. The allegation is that in September in Lockport Township, you stole some semi-truck rims which belonged to JCT Enterprises. I believe that's that place right at the intersection of South Main and M86. Is that correct? Is that place with all the railroad ties and stuff?
Yeah.
And there were two guys on bicycles and you left. Did you take some semi-tire rims?
Yeah, but
For scrap?
I couldn't possibly have done two guys on bicycles.
Well, that's what the report was. Uh, anyway, they saw you carrying a semi truck tire.
Where
What-
they seen,
It says Deputy Candolph said he was out with Brody Johnson on Broadway in South Main as he witnessed him riding his bicycle toward his residence while carrying a semi-tire truck rim. Brody said he bought the rim from Edward Fraze. And Ed Fraze says, I didn't sell him a tire rim. So anyway, the officer saw you with a rim. Did you take, it looks like just one semi-truck rim from this place?
I thought I bought it from Edward Fraze, but yeah, maybe.
All right, well, maybe. So did you take the rim from there?
From Edward Fraze?
Well, Edward Fraze has nothing to do with this place, so I guess it could be, did you buy it from him knowing that perhaps he stole it?
No, I bought it from him and yeah, maybe.
Well, what were you gonna do with it? What do you need a semi-truck rim for? What?
I bought it for scrap.
Yeah, that doesn't make any sense.
Mr. Johnson, do you remember this?
No, not correctly.
It's possible there was some intoxication present in Mr. Johnson's life at the time this happened. It's no contestably
All right.
acceptable to the prosecutor in the court.
It's acceptable to the court.
I think Mr. Johnson's attempted to take accountability for it.
Well,
but-
given the fact that he was dealing with Mr. Fraze, I tend to think there may be some degree of tax.
So either R and C, but I'll show no contest to larceny under 200. What do you get for a semi rim at scrap?
It weighs about 94 pounds and extrusion aluminum is about 87 cents a pound, so about $75.
A heavy thing to carry on a bike.
I'm not sure I could pick it up. All right. On the larceny, the thing was recovered. Let's see how many days credit you got there.
We can proceed on that victim too, Your Honor. There's no indication he has any.
Mr.
interest in
Solomon cares anything
speaking to
about
the
it.
court.
All right, on the larceny, I'm gonna give you 12 days credit, 12 days. Well, they could be a pretty valuable commodity if you could scrap these for 80 bucks a piece. We had an operation a number of years ago where they were stealing a bunch of rims from a RV factory, rims and tires. They would take them to the scrap shop and sell them. And then the RV company would go to the scrap place and buy them back. And then they'd steal them. It was like a closed loop. And they were stolen and repurchased several times until they finally caught up with the people. Show this as no contest.
Is it more or less lucrative than catalytic converters, Your Honor?
Well, they're less work.
It's true.
The real criminals there are the people that receive them,
Yep.
and they don't ever seem to catch up with them. Part of the larceny charge. 12 days, credit 12 days, concurrent with the A and B charge. Two five 2126. $125, the minimum allowable fine, or 2 additional days. All right. The assault and battery charge is a victim crime, which would normally require the court to set the matter out at least 10 days. Apparently, Mr. Solomon hasn't made any effort to answer his crime victims' rights. Notice. Mr. Gibson, is there anything you'd like to say to me about the assault and battery case?
Well, as far the victim in the case, when they reported it to the officer, they said that Brody Johnson had swung a piece of wood and that it didn't hit them, but it had hit a bicycle that they were on and broke a bicycle spoke, but he indicated that he was not injured. So this was, I believe, I guess you could say, an assault where he put someone in fear of the battery, but
Yes.
I don't necessarily know that there was any battery. So I would ask the court to sentence the defendant for credit for time served on that case. Thank you.
All right, I'm gonna do the same thing. It ain't exactly the crime of the century, and this isn't a innocent standby victim. He was a previous bad blood, an allegation that he had assisted or actually stolen money from the defendant. 12 days credit, 12 days concurrent with 2085. $283. And $125 or 2 additional days. So that takes care of both misdemeanor cases, which is worthwhile. Mr. Johnson, essentially, you just got time served. We have other matter we have to address.
Thank you.
We have a status conference in circuit court. Before you leave, Ross, they asked me to touch base with you about trying to get a plea in.
Yes, I've got that to talk to Jimmy about.
All right, I've got that in front of me. All right. Now, I'm just going to stay as part of the same record. There is a bond violation hearing and a status conference set for file 2025-25895. Mr. Truckee represents the defendant in that case, and he's charged in that matter with possession of methamphetamine. He was also charged, let me get these back up because I had a lot going on here. He has 2 pending felonies, as I mentioned earlier. This one, 2895, he had failed to appear several times, failed to appear for a pre-exam conference. Let me find my notes. And then he actually failed to appear for the preliminary examination. So I issued a bench warrant for his arrest. He also failed to appear for a status conference in circuit court on January 28th. Defendant failed to appear, prosecutor to issue bench warrant and bond forfeiture for both cases. So this is the notice of intent to forfeit the $12,500 bond signed by Judge Pattison. and the status conference today. So we've got the circuit court secretary with us, and that's helpful. So we have the issue of a bond violation bench warrant. The allegation, Mr. Johnson, is that you failed to appear for both your pre-exam conference, your prelim, and then a circuit court status conference on January 28th. Judge Stutzman issued a bench warrant, and we need to deal with that. I set bond in your other case at $15,000, the newer case, and apparently, according to the clerk, you've posted it. When I talked to you at your arraignment, originally I think it was a $5,000 bond or a PR bond. Anyway, I set it. And so you've posted the bond in your new case? How were you able to do that?
I think my family and racial.
Now, if I could just indicate to the court, the people's motion to cancel bond was done upon notification of the new charge that arose on the 25th of January, that being the possession of meth. We also, at that point in time, had a status conference set that he failed to appear for, and as a result, the bench warrant was issued. We can withdraw the motion to, the bond violation. I mean, it's the same basic set of facts. It's really, the question is what do you do with Mr. Johnson now? Because Mr. Johnson, apparently he did show back up for the PEC, because he didn't show up on 9/23, but on 9/30 of 25, he waived.
Yes.
So
That was after he was taken into custody.
Was he taken into
Yes,
custody?
he was in
Okay.
custody.
Oh, good. And then the problem that I'm concerned about is that I know that we had one status conference that was adjourned. An offer had been made. The offer wasn't accepted, but we agreed to adjourn it to clarify some other issues. And then when this next status conference came up in January, on the 16th, there was a no-show. On the 25th, there was a meth charge. At the meth charge, the notes with Miss Ives in our office indicate that the offer was made to plead to possession of meth as a drug double and deal with the other circuit court case. And it just disappeared. These things don't stay open long enough to be worth anything. But then there was an indication of the potential of adult drug treatment court, which Mr. Robert said he would consider if Mr. Johnson realized he'd have to plead to both circuit court felonies, the new one and this one. And Ms. Ives indicated she was going to talk to Mr. Johnson about that and possibly defer it. I would ask that in light of his failure to appear for a status conference when we were trying to resolve that case, and the fact that he picked up a new one, that no bond or a very high bond be set so that he can remain in jail, have a clear head, talk to either Ms. Ives or Ms. Truckee, and advise us what they want to do. They want adult drug treatment court based on Mr. Robert's indication. I would do the referral, but he has to be advised of what that means and all of that. And I don't know that he has yet, because that's Ms. Ives' case.
Well, there's an additional wrinkle that you had discussed, perhaps charging him with absconding for failing to appear. What that would result in, Mr. Johnson, is your family's put up a bunch of money to post your bond. I'd let you out of jail. You get rearrested for absconding, and all that money would be for naught. I've enjoyed talking with you today because you got your head on straight. We were able to resolve those two fairly inconsequential misdemeanor cases without much fuss. You got time served and the minimum allowable fine. So those are done. This is more serious. Now, I think you've got 10 days worth to think you could benefit from adult drug treatment court. My other concern is if I lay out on the street, you're just gonna right back in it. You failed to, nothing is labeled in here. It all says bind over. But there's a document in here from Community Corrections, pretrial release. See if I can find it. It all just says bind over. I don't know what I'm looking for. They do things differently in the circuit court than
It should
we
say
do.
community corrections correspondent. I can email it to you.
I'm looking for it.
Looks like it was filed on 3/24.
Oh, here it is. I didn't have it up. There it is. That's not it. Thank you. You failed to appear on 252083, failed to appear on 252126, failed to appear in 26113FY, and failed to appear twice in the felony case 2525895FH. So for status conference, well, we haven't got that far yet. Motion to revoke bond by prosecutor is granted. So we need an order revoking the bond. I'm going to reset the bond.
Your Honor, to clarify, you had earlier cited that 25895 was possession of meth. I want to clarify that that's unlawful driving away, receiving, concealing,
Yes,
and
thank you.
another one.
That's your case.
Yes, Your Honor.
Yeah, that's the case we're here on for status conference today.
And bench warrant arraignment.
And the bench warrant arraignment. So I've arraigned him on the bench warrant. We made a record of the multiple dates he failed to appear, including the other case. I set the bond at $15,000, thinking that would be sufficient. I don't want your family to spend a bunch of money that they're not going to get any return on. It isn't the kind of case, it's not a capital case, not an assaultive case that I believe I'm entitled to revoke the bond, to deny bond altogether. I'm going to set a new bond at $50,000 cash or surety. And then let's finish the arraignment. As to the status conference, there is an offer to plea to both felonies to be considered for adult drug treatment court. These pens are all dying. Is that correct, Mr. Gabriel?
Right, let me place the whole record place the whole offer on the record. And Ms. Ross can jot this on our status
All
conference.
right, that's twice now. It's Mr.
I know, I'm sorry, whatever. Long day.
Okay, sorry.
Here's our offer to resolve this.
All right.
If he wants adult drug treatment court, we would do the referral to see if he qualifies. I would agree to forego prosecution on the absconding charge if he qualifies. So I won't charge that. He would have to enter a plea to all the charges. That's part of the requirement in adult drug treatment court. If he understands what that's going to mean, being in the center and having controls on him, and he wants to do that, we would do that. If he doesn't want to do that, then the offer is going to be the original offer on Mr. Truckey's case, which was he could enter a plea to a 5-year felony of his choice and the 4th habitual. And then in the meth case, the global resolution would be he would plead to possession of methamphetamine as a drug double. That's a global offer, which deals with guilty pleas to those counts and no adult drug treatment court. Or the alternative is advise us he would like to find out if he qualifies. We'll do the referral, forward it to, I guess, Ms. Ives or Mr. Truckey, whoever wants it, to fill out their part, and we'll submit it to Clarence James for their analysis. It would be great to have Mr. Johnson in jail, because that way they can reach him, they can talk to him. He doesn't have to worry about missing any of the evaluation appointments, and maybe he can deal with this. That's the summation of our offer.
All right. So you've got a couple days to think about this. You've got the misdemeanors are done. I've set your bond substantially high, $50,000 cash or surety. I don't want you to get out and then immediately get recharged with absconding. I don't want you to get out and get on the street and relapse before you get a chance to get into programming. They're talking about potential Twin County Probation Center start into drug treatment court. We don't have do we set a trial date at this time, Joe?
I mean, we can. I don't have one available right now.
All
We
right,
can-
we probably don't. We don't even know what we have. We're gonna have visiting judges and, all right, so pending further trial date. What I would rather hope is it's set for a plea to one of these. My vote is for drug treatment court, but I don't control, you do. So you can discuss that with Ms. Ives, with Mr. Truckey, and if you're willing to do that, they can schedule it for a plea. If not, it can be set for.
Or possibly Mr. Stickley for reassignment to one attorney.
Yes, I would like that too. Ross has got a good handle on it. Good afternoon. All right, anything further we should place on the record?
I think not, Your Honor.
Nothing, Your Honor.
All right, thank you. Mr. Johnson, think about this.
Thank you, Your Honor.
All right, thank you for your help, Mr. Gabriel.
Gary, you want to go ahead and do that referral, please?
Yeah.
Thank you.
All right, Mr. Johnson can go back to jail.
Thank you, brother.
Thank you, Your Honor.
All right, good luck, sir. All right, Jill, have you got what you need there?
I did, and I'll go ahead and type up the orders and get them sent to you for signature.
All right, thank you. I've got some notes here, which will probably be unintelligible to you, but I'll provide those.
Okay, perfect. Thank you.
All right, thank you, Judge.
Thank you,
Have a happy Easter.
Now, let's talk about this other case.
Oh, yes.
I said, we were trying to find dates for you. I said, well, I can fit it in. It might be easier to find out when Ross is available.
I'm trying this vacation thing
Oh,
Monday, Tuesday, Wednesday. So that's why,
okay. Well, good for you. Well, that leaves Thursday.
yeah. And I've got some time Thursday, if you do, because I think you're also busy coming up.
Well, yes, but I'll be here. Let's look at April 9. I could fit it in on Thursday afternoon with, I think, are you set to be here? I don't think you
I will
are.
Judge Kane, but 3:45 or 4, I could.
All right, let's say 4 o'clock.
4 o'clock on next Thursday.
4 PM, April 9. All right, for plea. All right, thank you.
Thank you.
All right, good luck with that vacation thing. I know you don't do very much of it,
No.
and I think everybody should, so good for you.
Have a good Easter.
All right, I'll try. Pending future trial day.
Your Honor, let
Yes,
me have
sir.
a moment. Could I ask you one question? I don't have any case over. I just want to ask a question.
Okay, good afternoon. Give me just a moment here. All right, I'm gonna, well, all right. Why don't you come up to the podium?
Left side, right side?
Yeah,
Which side?
right here.
Here, oh yeah. So, my name is Vlad Vitsky, and I have my case fully dismissed by prosecutors.
I saw that.
Yeah, but there is one technicality in the case. So I'm a permanent resident, and I'm going to be applying for citizenship in this country, as well as I'm having a job with Federal Aviation Administration. So I'm going to be working for a contractor for Federal Aviation Administration. So the technicality is my case is dismissed because I complied with all terms of the plea agreement. However, when I spoke with prosecutors, they told me that means that I had an informal agreement with them. And it shouldn't be plea agreement because for federal government, in eyes of federal government, it looks like that I have accepted a plea, that like I plead guilty, you know. So I'm just looking for any way.
The way to do it isn't show up unannounced and have a hearing. You would file some sort of notice. We could give notice to the prosecutor. I don't have any objection to amending it to something that is acceptable to them. So if you file something in writing, we'll set it for a hearing and tailor the dismissal in a way that's acceptable to them and you. I forgot to check box number 7 to return all your information, and I amended that and hoped that it fixed it. But they prepared the dismissal, and that's the language they put on it.
Right.
So if you wish to challenge it, file something, we'll set a hearing and address it.
That's right, and I did that. I followed up with my lawyer, who is Luke Knopfsinger, and he tried to challenge it with prosecutor's office. And the whole prosecutor's office doesn't have an issue to change it. However, Gabby,
Yes.
he's very reluctant and he doesn't want to do anything. And Deborah Davis, she's on vacation right now. So he said there is nothing he can do because one person at the prosecutor's office is really reluctant of doing that. So I've spoken to Angelique Camfield. She was okay. Not I personally, because I can't, my wife. So I'm just, I don't have any other choice other than showing up here and asking you directly.
Well, the answer is no. If the prosecutor says no, I'm not going to change it. We can set it for a hearing. One of the problems is once Mr. Knopfsinger, once your case is dismissed, his obligation to represent you ceases. I guess your argument is the dismissal wasn't satisfactory for your purposes. I didn't go back and look at the record and see what was said as part of the agreement. But
it's just really hard to prove to federal government that I didn't have any plea.
Well, all right. I understand your play, but I can't fix it by you. I don't have the file in front of me. I don't know anything about it. You just show up one afternoon as I'm finishing a busy day.
Mhm.
I'm willing to address it when everybody's got a notice of the time. Yes, it's very serious stuff. A domestic assault charge could affect your ability to get permanent residency status. I don't really know much about the facts. And I don't know what language. Their position is it was a plea agreement. If you do this, we'll dismiss the charge. Your position is it was something other than a plea agreement.
It's important for my employment because federal government, I will be employed with federal government, and that's a problem for them. And they're going to run my background check.
I
And this is tricky.
understand, but we need to have a mechanism to actually have a hearing on it. Either, I don't know if Mr. Knopfinger was going to represent you or you're going to represent yourself, but I can't fix it by right here and right now. One option they could do is withdraw the plea, say, well, all right, if he doesn't like the way it was dismissed, I guess we'll reauthorize it. You run the risk of that, saying, you know, what I gave you was an outright dismissal of a domestic violence case. That's not good enough. I don't know what else to tell you. I suspect that's what Mr. Gabriel's position is. But I'd have to hear it from him. So I'm willing to hear it at a time scheduled where I give notice to the prosecutor. But I can't fix it here.
Okay, yeah.
Right.
Mr. Knopfinger, he's representing me right now, so he can
Okay.
file all necessary paperwork with you.
All right, very good. All right,
Thank you very much.
Okay. All right, we'll have that for a later date. All right, that finishes our messy, busy day. I'm gonna stop the live feed. We'll be back Monday.
What we just witnessed is a perfect example of how quickly things can escalate in the justice system, even when the original charges seem minor. On the surface, this case involved low-level offenses like larceny under $200 and a relatively minor assault allegation. And in those instances, the judge showed leniency, granting time served and minimal fines. But the real story here isn't about those misdemeanors, it's about patterns. Repeated failures to appear in court, new felony charges, and a potential substance abuse issue completely shifted the judge's approach. That's why we saw a dramatic jump in bond, from manageable to $50,000 cash or surety. That's not just punishment. That's the court trying to regain control of a situation that's slipping. And then comes the turning point, drug treatment court. This isn't just another legal option, it's a fork in the road. One path leads toward rehabilitation and a structured second chance. The other could mean years behind bars with felony convictions stacking up. So now we turn it over to you. Do you think the judge made the right call by increasing the bond and pushing for treatment court? Or should the defendant have been given another shot at release? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.